Hello everyone, good morning to all of you. Today, me and my group members will talk about an assignment which is totally based upon Sikome Lake. Actually, this case happened in 2001 in the Court of Queen Bench, and the name of this case is Miss MC Queen versus Alberta. The purpose of this case is to analyze the facts, legal issues, and something more. And if I talk about the parties that are involved in this case, actually there are two parties that are involved. The first one is plaintiff and the second one is defendant. And if I talk about the overview of that incident, actually there was a lake over there and the name of that lake was Sikome Lake. Sikome Lake is a man-made swimming covering 3.8 acre at the south end of the Calgary, and in June 15, 1994, David MC Queen came to that lake with his whole family. MC Queen dropped his children onto a swimming lake near the swimming lake, and MC Queen dove into the water with the depth of 1.2 feet. The skimmer platform and developed a spiral cord injury which made him paralytic. So the next part will be explained by Rajanveer.
Facts of the case: legal action, McQueen squared Alberta and Calgary alleging negligence. The second one is claimed lack of adequate warning and failure to prevent dangerous activity. Now, further procedural background. First, case heard in Alberta Court of McQueen bench. Second one is defendant argued they fulfilled their duty for care under the Occupiers Liability Act. And the third one is court ruled on whether they are legal responsible for McQueen's injury. And now going ahead, issues in McQueen v Alberta. Did the province of Alberta breach its duty to care to McQueen? And the second is, was McQueen injury is a result of this breach? Was the risk of injuries foreseeable? And the last one is, to what extent MC Queen contribute negligently?
Holding in MC Queen versus Alberta. Rule of law applied. The first rule is property owners must follow the rules set by the Occupiers Liability Act when they provide care to their visitors. The second one is under legal criteria, the defendant must demonstrate their implementation of sufficient precaution for reversible injuries. And the second type is court decision. The first decision is the judicial decision was presented in support of Alberta and the city of Calgary. Second one is a court found that safety precaution at Scone Lake were appreciated. Thank you.
Rationale in McQueen versus Alberta. Duty of care met. The Occupiers Liability Act responsibilities were properly enforced by Alberta along with Calgary. Safety precaution along with the warning indicator existed in sufficient number. Personal responsibilities. McQueen's drunken state combined with his reckless behavior caused the major part of his injury. Any court eviction combines foreseeable adverse effect and actual personal conduct as indicator of liabilities. Procedure as legal principles. According to previous judicial decision, occupiers maintain no obligation to fully ensure safety of their premises. According to the law, a person should maintain reasonable caution but does not need to ensure all safety at all times.
Hello, my topic is rational in McQueen versus Alberta. The first one is public policy consideration. Imposing liability may reduce risk of recreation facilities due to increase in legal risk and cost. Encouraging personal responsibilities ensures individual to take precautions while other to safety norms promotes a shared society culture. The second one is final justification. in which the injuries related from unrelated factors means not on a branch of duty. This decision reinforces the principle that liabilities requires clear negotiation, protecting public entities from undue legal responsibilities in such cases. The court found no negotiation by the defenders, ruling that Alberta and Calgary. And that's all from my team. And this is the end of the assignment. Thank you and have a nice day.